The notice taped to my front door wasn't just insulting. It was potentially going to cost me $5,000, and I hadn't even known I was breaking any rules until that Tuesday morning in September. I stood there on my porch in Asheville, North Carolina, staring at the bright orange violation notice that flapped in the mountain breeze. My coffee had gone cold in my hand. The paper stated in bold letters that my gravel driveway was in violation of the Mountainside Estates HOA covenant, requiring all driveways to be paved with asphalt or concrete. I had 30 days to comply or face escalating fines starting at $500 per week. My name is Kevin Jamison, and I had lived in this house for 3 years without a single complaint. More importantly, this gravel driveway had been here long before I bought the place. I stood there looking at it, the morning sun making the crushed granite sparkle like it always did. It was beautiful, well-maintained, and perfectly functional. I edged it twice a year, kept it level, and added fresh gravel when needed. It was one of the reasons I bought this property in the first place. The driveway had character, unlike the sterile black asphalt strips that led to every other house in the neighborhood. I pulled the notice off my door and went inside, immediately heading to my home office. The house had been built in 1978 according to my property records, and I knew for a fact that Mountainside Estates HOA wasn't established until at least 15 years later. I had done my research when buying the house, though admittedly I hadn't looked deeply into every single covenant. The real estate agent had mentioned the HOA was relatively hands-off, which had been true for the 3 years I lived here. Until now. I pulled out my closing documents from the filing cabinet and started spreading them across my desk. The property disclosure showed the driveway as gravel. The inspection report noted the gravel driveway in good condition. Even the appraisal mentioned it. Everything pointed to this being an existing feature of the property, not something I had added or changed. My phone rang. It was my neighbor, Tom, who lived 2 houses down. "Did you get one too?" he asked before I could even say hello. "The violation notice?" "Yeah, just found it on my door. Same here. Apparently my fence is 6 inches too tall. 6 inches, Kevin. It's been there since 1985. I bought the house with that fence." "Who signed the notice?" "I'm looking at mine now." "Brenda Morrison. She's the new HOA president. Moved in about 4 months ago and immediately got herself elected. Only 12 people showed up to vote, so it wasn't hard for her and her friends to take over the board." I looked at the signature line. Sure enough, Brenda Morrison, in aggressive, looping handwriting that practically stabbed through the paper. "What are you going to do?" Tom asked. "Fight it. This driveway was here decades before the HOA existed. There's no way I'm ripping it up and spending 10 grand on asphalt because some new board president wants to flex. Good luck, man. Let me know if you need anything. I'm taking photos of my fence and looking for my old property records. This is ridiculous." After hanging up, I spent the next 2 hours digging through every document I had. Then I went online and started researching North Carolina HOA law. What I found was promising. North Carolina had strong protections for pre-existing conditions on properties, especially those that predated HOA establishment. The legal term was grandfathered in, and if I could prove my gravel driveway existed before the HOA's covenants were recorded, I had a solid case. The problem was proving it. I needed documentation from before the HOA existed. My property records only went back to when I purchased the house. I needed to dig deeper. I drove to the Buncombe County Register of Deeds office that afternoon. The building was downtown, a sturdy brick structure that had probably been there since the 70s itself. Inside, A helpful clerk named Patricia directed me to the property records department. I need to see the complete chain of title for my property, including any surveys or improvement records, I explained, sliding my property information across the counter. Patricia adjusted her glasses and typed into her computer. That's going to go back a while. When was the house built? 1978. Okay, let me pull up what we have in the system. Some of the older records are still on microfiche, but we've been digitizing. Her fingers clicked across the keyboard for several minutes. Here we go. I'm seeing the original building permit from 1977, construction completed in 1978. There's a survey from that time too. Let me print these for you. While she worked, I asked, would there be any records of when the driveway was installed? If it was part of the original construction, it would be on the site plan attached to the building permit. If it was added later, there might be a separate permit, though driveways didn't always require permits back then depending on the scope of work. The printer hummed to life, spitting out pages. Patricia handed them to me, and I immediately scanned through them. There it was on the original site plan, clear as day. A driveway marked with the notation crushed granite. The date on the document was March 1978. This is perfect, I said. Can I get a certified copy of this? Absolutely. That'll be $15 for the certification and seal. I gladly paid and waited while she prepared the official document. Then I asked the crucial question. When was the Mountainside Estates HOA established? Would you have those records too? HOAs file their covenants and bylaws with us when they're created. Let me look. More typing. Mountainside Estates Homeowners Association, filed November 1993. Want me to print the original filing? Yes, please. This was even better than I hoped. My driveway predated the HOA by 15 years. There was no possible way their covenants could apply to a feature that existed long before the organization itself. Armed with my certified documents, I went home and drafted a response letter. I kept it professional but firm, citing North Carolina General Statute 47F, which governed HOAs in the state and included provisions for pre-existing conditions. I attached copies of my certified documents and requested the violation be dismissed immediately. I sent the letter via certified mail the next morning, requiring a signature upon delivery. Then I waited. 4 days later, my phone rang from an unknown local number. Mr. Jamison, this is Brenda Morrison, president of the Mountainside Estates HOA board. Her voice was exactly what I expected, sharp, clipped, and radiating annoyance. Hello, Mrs. Morrison. I assume you received my letter. I did, and I'm calling to inform you that your violation stands. The documents you provided don't change anything. All properties in Mountainside Estates must comply with current covenants, regardless of when features were installed. I kept my voice level. That's not how the law works. Pre-existing conditions that predate HOA establishment are grandfathered in. I have certified documentation proving my driveway was installed in 1978, 15 years before your HOA even existed. The law is irrelevant here, Mr. Jamison. When you purchased your property, you agreed to abide by our covenants. That means bringing your property into compliance. I agreed to abide by reasonable covenants that don't violate state law. You can't force me to remove a feature that legally predates your authority. Her voice went up a notch. I absolutely can, and I will. You have 26 days remaining to pave that driveway, or the fines begin. $500 per week, Mr. Jamison. That adds up quickly. Then I'll see you in court, Mrs. Morrison, because I'm not paying a single cent in fines and I'm not touching my driveway. We'll see about that. She hung up without another word. I sat there holding my phone. anger bubbling in my chest. This woman was either completely ignorant of the law or didn't care. Either way, she was in for a surprise. Over the next week, 3 more neighbors received violation notices for various pre-existing features. Tom's fence, Margaret's decorative front gate, and even old Mr. Chen's rock garden that he'd maintained since 1982. Brenda was clearly on a campaign to remake the neighborhood according to her vision. Existing features be damned. We all met at Tom's house that Saturday afternoon. 5 of us total, all facing ridiculous violations and potential fines. "She's trying to force us out," Margaret said. She was 72 and had lived in her house for 27 years. "These fines are designed to make us sell. She probably has friends waiting to buy our properties." "That's a serious accusation," I said. "Do you have any evidence?" "Not concrete, but think about it. She moves in, immediately takes over the HOA, and starts hitting the oldest properties with violations for features that have been here for decades. It's a pattern." Mr. Chen, who was 80 and usually quiet, spoke up in his accented English. "My rock garden was approved by original developer. I have letter from 1982. She says it doesn't matter, must remove rocks and plant grass." "This is insane," Tom said. "We should all fight this together. Pool resources, maybe hire a lawyer." "I've already contacted a real estate attorney," I said. "Her name is Rachel Kim, and she specializes in HOA disputes. She's looking at my case and said if any of you want to join, she can represent multiple homeowners. It'll be cheaper that way too." Everyone agreed immediately. We exchanged contact information and decided to meet with Rachel together the following week. Rachel Kim's office was in a renovated warehouse in the River Arts District. She was in her mid-40s, with sharp eyes and an air of competence that immediately put me at ease. We all crowded into her conference room, and she listened intently as each of us presented our cases. "This is a clear pattern of harassment," Rachel said after we finished. "Mrs. Morrison is violating multiple state statutes regarding HOA governance and enforcement. The good news is that all of you have strong cases for grandfather protection. Kevin's is the most straightforward since he has certified documentation, but even without that, North Carolina law presumes pre-existing features are allowed unless the HOA can prove they were installed after covenant establishment." "So what do we do?" Margaret asked. "First, I'm going to send a cease and desist letter to the HOA board on behalf of all of you. This will formally notify them that their enforcement actions are illegal and demand immediate withdrawal of all violations. If they refuse, we file in district court for declaratory judgment and injunctive relief." "How much is this going to cost?" Tom asked. "For all 5 of you together, I can do the cease and desist for $2,000 total, $400 each. If we have to go to court, figure another $1,500 per person, but the good news is that North Carolina law allows recovery of attorney fees in HOA disputes when the HOA acts in bad faith. If we win, and I'm confident we will, the HOA pays all your legal fees." That was acceptable to everyone. We each wrote checks and signed representation agreements. Rachel said she'd have the cease and desist letter sent within 2 days. I drove home feeling better than I had since finding that orange notice on my door. Having a lawyer on my side changed everything. This wasn't just me against an unreasonable HOA president anymore. This was a legal battle, and I had the law on my side. The cease and desist letter was delivered to Brenda Morrison on Wednesday via process server. Rachel sent me a copy. It was 5 pages of legal reasoning, citations to relevant statutes, and a firm demand that all violations be withdrawn within 10 days or face litigation. Brenda's response came faster than expected. That Friday evening, I found another notice on my door. This one informed me that I was being fined $500 for disrespectful communication with HOA board members, and another $500 for attempting to intimidate the board with legal threats. I actually laughed out loud. This woman was digging her own grave. I immediately scanned the notice and emailed it to Rachel. She called me within an hour. "She's retaliating," Rachel said, and I could hear the satisfaction in her voice. "This is exactly what we need. Retaliation is explicitly prohibited under North Carolina HOA law." She just handed us an even stronger case. "So what happens now?" "Now we file in court. I'll have the complaint ready by Monday. We're going to ask for declaratory judgment that your driveway and the other features are grandfathered in, an injunction preventing the HOA from assessing any fines, and damages for harassment and retaliation, plus attorney fees. How long will this take?" HOA cases usually move pretty fast in Buncombe County. Figure 2 to 3 months to get a hearing. In the meantime, don't pay any fines and document everything. If she continues retaliating, it just strengthens our case. That weekend, Brenda sent violation notices to 7 more properties. The woman was on a rampage. Most of the new violations were for trivial things. A basketball hoop that had been there for years, Christmas decorations that supposedly violated size restrictions, even though it was September, and there were no decorations up, a vegetable garden that allegedly violated landscaping rules. Word spread through the neighborhood fast. By Monday, Rachel had 12 clients ready to file a joint action against the HOA. The story even made the local news. A reporter from the Asheville Citizen-Times called me for an interview. "I just want to live in my house with the driveway that was here decades before anyone thought to create an HOA," I told him. "This isn't about being difficult or flouting rules. This is about protecting property rights and preventing HOA overreach." The article ran on Wednesday with the headline, "Local Homeowners Fight HOA Over Pre-Existing Features." It included a photo of my gravel driveway looking pristine in the morning sun and quoted Brenda saying, "Rules are rules, and everyone must comply for the good of the community." That night my doorbell rang at 8 o'clock. I opened it to find a nervous-looking man in his 60s standing on my porch. "Kevin Jamison. I'm Harold Morrison, Brenda's husband. I wasn't expecting that." "Okay, what can I do for you? Can I come in?" "I need to talk to you and I'd rather not do it on your porch." I hesitated, then stepped aside. "Sure." We sat in my living room. Harold looked uncomfortable, his hands clasped between his knees. "I want to apologize for my wife," he said. She's not well. Mentally, I mean. She's become obsessed with the HOA since we moved here. I thought it would be good for her to have a project, something to focus on, but it's gotten out of control." "Harold, I appreciate you coming here, but your wife is violating state law and harassing homeowners. An apology doesn't fix that." I know, but she won't listen to me. She's convinced she's protecting property values and maintaining community standards. I've tried to talk to her, but she just gets angry." He looked up at me with tired eyes. "Is there any way to resolve this without court?" "I'm worried about what this stress will do to her. Your wife has violated my property rights and threatened me with thousands of dollars in illegal fines. She's done the same to 11 other homeowners. Some of them are elderly and on fixed incomes. She's caused real harm and real stress. So no, I'm not interested in resolving this quietly. She needs to withdraw every violation, resign from the board, and agree to never hold an HOA position again." Harold's shoulders slumped. "She'll never agree to that. Then we'll see her in court." He left looking defeated. I actually felt a little bad for him, but not enough to back down. Brenda had made her choices. She could live with the consequences. The court filing happened the following Monday. Rachel filed a civil complaint in Buncombe County District Court on behalf of all 12 homeowners. The complaint was 42 pages long and included exhibits showing each property's pre-existing features, the HOA's covenant filing date, and a timeline of Brenda's enforcement actions and retaliatory behavior. The HOA had to respond within 30 days. During that time, Rachel also filed for a temporary restraining order preventing the HOA from assessing or collecting any fines while the case was pending. The judge granted it within a week. I thought that would calm things down. I was wrong. 2 weeks after the restraining order was issued, I came home from work to find my mailbox bashed in. It was lying in pieces on the ground, clearly hit with something heavy. My gravel driveway had deep tire ruts gouged through it, like someone had done donuts in a truck. I immediately called the police. Officer Jamison showed up 20 minutes later and took my statement. "Any idea who might have done this?" he asked, photographing the damage. "I'm in a legal dispute with my HOA president. It's been getting ugly. You think she did this?" "I think she might know who did. We're in court over her trying to fine me for this driveway. Now suddenly it's damaged." "That's pretty circumstantial, but I'll file a report. You should set up cameras if you don't have them already. If this happens again and you catch it on video, we can actually do something." I took his advice. That afternoon, I ordered a comprehensive security camera system and had it installed 2 days later. 4 cameras covering the front yard, driveway, and side of the house. High definition, night vision, motion detection, the works. 3 other homeowners in our lawsuit reported similar vandalism that same week. Tom's fence got spray painted. Margaret's decorative gate was damaged. Mr. Chen's rock garden had rocks thrown through his front window. The police took reports, but couldn't do much without evidence. The neighborhood was on edge. Rachel filed an emergency motion with the court reporting the vandalism and asking for additional protective orders. The judge scheduled a hearing for the following Friday. That Wednesday night, my cameras caught something interesting. At 2:15 in the morning, a truck drove slowly past my house, paused, and someone in the passenger seat appeared to photograph my property. The license plate was clearly visible. I downloaded the footage immediately and called Officer Jamison in the morning. He ran the plate. "Registered to Gary Morrison at your address for Brenda Morrison," he told me. "That's interesting. Can you do anything with this?" They didn't commit a crime by driving on a public street or taking photos, but it's definitely suspicious given the context. Save that footage for your court case. If any more vandalism happens, this establishes a pattern of behavior. The Friday hearing was tense. All 12 homeowners showed up, along with Rachel. The HOA was represented by a lawyer named Douglas Fletcher, who looked like he'd rather be anywhere else. Brenda sat behind him, arms crossed, glaring at everyone. The judge, a no-nonsense woman named Patricia Winters, reviewed the emergency motion and the evidence of vandalism. "Mr. Fletcher, what's your client's position on these allegations?" she asked. Fletcher stood. "Your Honor, Mrs. Morrison categorically denies any involvement in vandalism. These are serious accusations without evidence connecting her to any criminal activity." Rachel stood. "Your Honor, we have evidence of Mrs. Morrison's vehicle driving past my client's property at 2:15 in the morning, clearly surveilling the damage. We have a pattern of escalating retaliation against homeowners who dared to exercise their legal rights. While we cannot yet prove she personally committed vandalism, the circumstantial evidence is compelling." Judge Winters looked at Brenda. "Mrs. Morrison, Why was your vehicle driving past Mr. Jamison's house at 2 in the morning? Brenda stood up despite Fletcher trying to stop her. I have every right to drive on public streets in my own neighborhood. I was checking for covenant violations. That's my job as HOA president. At 2 in the morning, violations can occur at any time. Judge Winters looked unimpressed. Sit down, Mrs. Morrison. She reviewed some papers on her bench. Here's my ruling. The temporary restraining order preventing fine assessment remains in place. Additionally, I'm ordering Mrs. Morrison and any agents of the HOA to maintain a distance of at least 100 feet from the plaintiff's properties, unless conducting legitimate HOA business during reasonable hours, defined as between 9 a.m. and 6 p.m. Any further vandalism or harassment will result in contempt charges. The main hearing on the merits is scheduled for November 15th. That gives both sides 2 months to prepare. Anything else? Fletcher shook his head. Rachel said, No, Your Honor. Good. Everyone behave yourselves until November. We filed out of the courtroom. In the hallway, Brenda walked right up to me, stopping just short of the 100-foot order since we were in the courthouse. You're destroying this community, she said. Property values will tank because you and your friends refuse to maintain standards. The only thing destroying this community is you, Brenda. You moved into a neighborhood with established homes and established features, and you decided to play dictator. You're going to lose in court, and you're going to pay all our attorney fees. That's what happens when you abuse your position. Her face went red. We'll see about that. Fletcher grabbed her elbow. Mrs. Morrison, please stop talking. She shook him off and stalked away. Fletcher gave me an apologetic look and followed her. That woman is unhinged, Tom muttered next to me. Yeah, but she's also constrained now. Judge's order means she can't harass us directly anymore. The next 2 months were relatively quiet. Brenda apparently took the judge's order seriously, and there was no more vandalism. My security cameras recorded nothing but the occasional cat and delivery drivers. The neighborhood started to relax slightly. I spent that time helping Rachel prepare for the hearing. We gathered every piece of documentation possible. I found old newspaper archives from 1978 showing homes under construction in Mountainside Estates, and you could see gravel driveways in the background of photos. Tom found the original developer's architectural guidelines from 1977, which explicitly allowed gravel driveways as an option. Margaret discovered something even better. The original HOA filing from 1993 included a grandfather clause specifically stating that existing property features would not be subject to new restrictions. It was right there in the bylaws, apparently added by the original homeowners who created the HOA specifically to prevent future boards from doing what Brenda was trying to do. This is gold, Rachel said when Margaret showed her. They included a grandfather clause in their own governing documents. That means even if state law wasn't clear, their own rules protect you. As November 15th approached, the HOA made a last-minute settlement offer. Fletcher called Rachel with a proposal. The HOA would withdraw all violations and agree not to enforce certain covenants against pre-existing features, in exchange for the homeowners dropping the lawsuit and paying their own attorney fees. We had a conference call with all 12 plaintiffs to discuss it. It's not a terrible offer, Rachel said. You'd get what you want, which is to keep your driveways and fences and gardens, but you'd be out the legal fees we've accumulated, which is about $1,800 per person at this point. What are our chances if we go to trial? I asked. Excellent. 90% or better. Between the state law, the certified documents, the original HOA bylaws with the grandfather clause, and the evidence of retaliation, we have an overwhelming case. If we win, the HOA pays all attorney fees plus potential damages. Then I say we go to trial, I said. This isn't just about the money. Brenda needs to learn she can't abuse her authority. If we settle, she'll just do this to someone else later. Everyone agreed. We rejected the settlement offer. The hearing finally arrived on a cold November morning. Judge Winters presided in a half-full courtroom. This wasn't a jury trial, just a hearing on the merits where the judge would make a ruling based on law and evidence. Rachel presented our case methodically. She entered into evidence the certified property records showing driveway installation dates, the HOA covenant filing date, the state statutes protecting pre-existing conditions, and the HOA's own grandfather clause. She called me to testify first. Mr. Jamison, when did you purchase your property? October 2021. And what was the condition of the driveway when you purchased it? It was gravel, well-maintained, the same as it is today. Did you make any changes to the driveway after purchasing? Only maintenance. I've added fresh gravel once and edged it twice a year to keep it looking neat. When did you first learn the HOA had an issue with your driveway? September 17th of this year, when I found a violation notice on my door. What was your reaction? Confusion, initially. The driveway had been there for decades without issue. Then anger when I realized they were threatening thousands of dollars in fines for something that wasn't my fault and was legally protected. Fletcher cross-examined me, but his questions were weak. He couldn't challenge the basic facts. Instead, he tried to argue that I should have known the covenants when I bought the property and should have proactively paved the driveway. Mr. Jamison, didn't you review the HOA covenants before purchasing? I reviewed them generally. They didn't mention anything about existing features needing to be changed. But you knew the covenant required paved driveways. I knew that was the requirement for new construction or new installations. I had no reason to believe it applied retroactively to a driveway installed in 1978. Did you ask? Why would I? The driveway was already there. It would be like asking if I needed to change the color of the house or the type of roof shingles. Those were existing features of the property. He couldn't shake me. Rachel called Tom next, then Margaret, then Mr. Chen. Each testified to the same pattern. Pre-existing features, sudden violations from Brenda, threats of enormous fines. Then Rachel called Harold Morrison. That was a surprise to everyone, including apparently Brenda, who audibly gasped when her husband was called to the stand. Harold was sworn in and sat down, avoiding his wife's stare. Mr. Morrison, what's your relationship to defendant Brenda Morrison? She's my wife. Are you familiar with her activities as HOA president? Fletcher objected. Your Honor, spousal privilege. Judge Winters looked at Harold. Mr. Morrison, are you invoking spousal privilege? Harold shook his head slowly. No, Your Honor. Then proceed, Miss Kim. Rachel continued. Are you familiar with your wife's activities as HOA president? Yes. I've tried to get her to stop this, but she won't listen. Stop what specifically? The violations, the fines, all of it. I told her these people's driveways and fences were here long before we moved in. I told her she was going to get sued. She said she didn't care, that someone had to maintain standards. Did your wife ever express why she was targeting these specific properties? Fletcher objected again. Hearsay. Your Honor, this goes to state of mind and motive. I'll allow it. Answer the question, Mr. Morrison. Harold took a breath. She said the neighborhood looked too old-fashioned. She wanted everything modern and uniform. She said if some of the older residents couldn't afford to upgrade their properties, maybe they should sell and move somewhere more affordable. A murmur went through the courtroom. Brenda looked like she wanted to murder her husband. Did she ever discuss property values or potential purchases? She talked to a real estate investor friend about opportunities in the neighborhood. I heard her say that if some properties turned over, her friend could renovate and flip them. Objection. Fletcher was on his feet. This is wildly speculative and prejudicial. Your Honor, it establishes motive for Mrs. Morrison's pattern of harassment. Judge Winters considered. I'll allow the testimony, but Mr. Fletcher, you'll have opportunity to cross-examine. Fletcher did cross-examine, trying to portray Harold as a disgruntled husband exaggerating private conversations. But the damage was done. The testimony painted Brenda as someone with financial motivations beyond mere covenant enforcement. The HOA put on a weak defense. Fletcher called Brenda to testify, which was a mistake. She was combative and dismissive on the stand. Mrs. Morrison, why did you issue violation notices to these homeowners? Because they were in violation of HOA covenants. It's my job to enforce the rules. Were you aware these features predated the HOA? That's irrelevant. Current homeowners must comply with current rules. Even if those rules conflict with state law, HOA covenants supersede state law within the community. I saw Judge Winters' eyebrows go up at that statement. Rachel smiled slightly. Fletcher looked pained. Mrs. Morrison, that's not actually correct. I know the law, Mr. Fletcher. I've read the covenants thoroughly. Everyone must comply. Even if the HOA's own bylaws include a grandfather clause, she waved a hand dismissively. That clause was a mistake by the original board. It shouldn't be enforced. You can't simply ignore provisions of your own governing documents. I can when they're bad provisions. Fletcher gave up and sat down. Rachel's cross-examination was brutal. Mrs. Morrison, you testified that HOA covenants supersede state law. Where did you learn that? It's common sense. People agree to abide by HOA rules when they buy property. But you understand that's not legally accurate, correct? State law explicitly governs HOA operations. I don't accept that interpretation. You don't accept North Carolina General Statute 47F. I think it's overly broad and interferes with private governance. So you knowingly violated state law. I enforced HOA covenants as I saw fit. And when homeowners challenged you with legal documentation, you retaliated with additional fines, correct? I assessed legitimate violations, including fining Mr. Jamison for disrespectful communication after he sent you a cease and desist letter. He was disrespectful. Is it disrespectful to exercise one's legal rights? Brenda just glared at her. Mrs. Morrison, did you drive past Mr. Jamison's property at 2:15 in the morning? I was checking for violations. At 2 in the morning, violations can occur at any time. Isn't it true you were surveilling damage to his property that occurred earlier that evening? I don't know what you're talking about. Your vehicle was photographed on his security camera at 2:15 a.m., hours after vandalism occurred to his driveway. I was just driving through the neighborhood. Rachel let that hang in the air, then said, "No further questions." The hearing concluded with closing arguments. Rachel methodically went through the law, the evidence, and the testimony, building an overwhelming case that the HOA had violated state law and its own governing documents. Fletcher did his best to argue that HOAs needed enforcement power and that some flexibility in interpretation was reasonable, but his heart clearly wasn't in it. Judge Winters said she'd issue a written ruling within 2 weeks. Those 2 weeks felt longer than the previous 2 months. I went about my daily life, working my job as an IT consultant, maintaining my gravel driveway, trying not to obsess over the case. But it was hard not to think about it constantly. The ruling came down on December 1st. Rachel called me immediately. We won, complete victory on every count. I sat down heavily on my couch. "Tell me everything." Judge Winters ruled that all pre-existing features are legally protected under both state law and the HOA's own grandfather clause. She permanently enjoined the HOA from enforcing any covenants against features that existed before 1993. She awarded damages for harassment and emotional distress, $5,000 per plaintiff, and she ordered the HOA to pay all attorney fees and court costs. I did the math quickly. That's $60,000 in damages plus attorney fees. The HOA doesn't have that kind of money. That's their problem. The judgment is against the HOA entity, and if necessary, it can be collected from board members personally if they exceeded their authority, which Judge Winters noted they did. Brenda Morrison is personally on the hook for a significant portion. What about the vandalism? Judge Winters noted the suspicious circumstances in her ruling and referred the matter to the district attorney's office for potential criminal investigation. That's separate from our civil case, but it could lead to charges. I felt a wave of relief wash over me. It was over. I could keep my driveway, Brenda was held accountable, and the neighborhood was protected from future overreach. The other homeowners were ecstatic when Rachel called them. We decided to meet for a celebration dinner at a local restaurant that weekend. It felt good to gather without the cloud of litigation hanging over us. "To property rights and common sense," Tom toasted, raising his beer. "And to Rachel for taking this case," Margaret added. We drank and ate and shared stories about the case and our relief that it was over. Mr. Chen was particularly happy. "Now I can tend my rock garden in peace," he said with a smile. The aftermath took a few more weeks to play out. The HOA held an emergency board meeting to address the judgment. Brenda refused to resign despite calls from other homeowners. The HOA's insurance declined to cover the judgment, calling it willful misconduct. That left the HOA itself responsible for the full amount. The HOA had about $12,000 in reserves. That wasn't nearly enough. To avoid personal liability, the other board members resigned en masse, leaving only Brenda. She finally resigned 2 weeks before Christmas, issuing a bitter statement about ungrateful homeowners and deteriorating standards. A new board was elected immediately, composed of longtime residents who had no interest in aggressive enforcement. One of their first acts was to formally adopt a policy that all pre-existing features were presumptively allowed, and that any enforcement actions required majority board approval and documented covenant violations. The district attorney did investigate the vandalism. In January, charges were filed against Gary Morrison, Brenda's adult son who lived with them. Apparently, he'd admitted to his girlfriend that his mother had asked him to send a message to the troublesome homeowners. The girlfriend, feeling guilty, went to the police. Gary was charged with multiple counts of vandalism and criminal mischief. He took a plea deal that included probation, restitution, and community service. Brenda herself wasn't charged criminally, but the civil judgment remained. She ended up having to sell her house to pay her portion of the damages and attorney fees. She and Harold moved out of Mountainside Estates in March. I heard they went to Florida. My gravel driveway remains as beautiful as ever. I maintain it carefully, adding fresh crushed granite every spring. It's a reminder of the importance of standing up for your rights and not backing down when authorities overreach. Tom's fence is still 6 inches too tall by the old standard, and nobody cares. Margaret's decorative gate welcomes visitors to her home. Mr. Chen's rock garden blooms with carefully placed stones and alpine plants. The neighborhood looks exactly as it should, lived in, established, and respected. I learned several valuable lessons from the experience. First, Always research property rights thoroughly when buying a home and keep meticulous records. Those certified documents from the Register of Deeds were crucial to my case. Second, don't be afraid to fight back when someone abuses their authority. Brenda counted on homeowners being too intimidated or too cash-strapped to challenge her. When we stood together, she couldn't win. Third, HOAs can serve a legitimate purpose, but they need oversight and accountability. The new board in Mountainside Estates functions well because they understand they're stewards of the community, not rulers of it. The lawsuit also sparked some local media attention about HOA overreach in North Carolina. The Asheville Citizen-Times ran a follow-up story about our victory, and I was interviewed by a local TV news station. Several other homeowners in different subdivisions reached out to Rachel about their own HOA disputes. Some of those cases are still ongoing, but our victory set a precedent that's helping others stand up for their rights. One unexpected benefit was how the whole ordeal brought the neighborhood together. Before the lawsuit, most of us waved politely but didn't really know each other. Now we have regular gatherings, help each other with yard work, and look out for one another. Tom and I became good friends. Margaret treats me like a grandson. Mr. Chen taught me about rock gardens, and I'm planning to add one to my backyard this spring. The financial outcome was positive too. Each of us received our $5,000 damage award plus reimbursement of all attorney fees. I actually came out slightly ahead after the dust settled. More importantly, I didn't have to spend $10,000 ripping out my driveway and paving it. Property values in Mountainside Estates, contrary to Brenda's predictions, have remained stable. Turns out that mature neighborhoods with character are desirable, and people appreciate homes with unique features rather than cookie-cutter uniformity. The whole experience taught me about the power of documentation and the importance of knowing your rights. When that first violation notice appeared on my door, I could have panicked or given in. Instead, I did my research, found the law, gathered evidence, and fought back systematically. That approach made all the difference. It also taught me about the danger of giving individuals unchecked authority. HOAs serve a purpose in maintaining community standards and managing shared resources, but that authority must be balanced with homeowner rights and legal constraints. Brenda saw herself as improving the community, but she was really just imposing her personal preferences and possibly enriching herself through forced property turnovers. The law exists to prevent exactly that kind of abuse. Looking back, I'm grateful for Judge Winter's thorough ruling. She didn't just side with us. She explained in detail why HOAs must respect both state law and their own governing documents. She called out Brenda's behavior as retaliatory and potentially criminal. She awarded damages that actually mattered. That ruling will stand as precedent for future cases in Buncombe County, and serves as a warning to other HOA boards that might be tempted to overreach. I sometimes drive through other neighborhoods and notice similar situations. Well-maintained older homes with features that might not match current HOA standards, but clearly predate them. I wonder how many homeowners are facing similar pressure from overzealous boards. I hope they know they have rights and options. I hope they stand up for themselves like we did. My gravel driveway sparkles in the afternoon sun as I write this, looking exactly as it did when it was installed in 1978 and exactly as it should. It's more than just a place to park my car. It's a symbol of property rights defended, community solidarity, and the principle that existing peacefully in your home is a fundamental right that no HOA board should be able to take away on a whim. The story has a postscript that occurred just last month. I ran into Harold Morrison at a coffee shop in downtown Asheville. We recognized each other immediately. There was an awkward moment, then he approached me. "Kevin, I want to apologize again for everything Brenda put you and the others through." "Harold, you already apologized, and honestly, you were one of the good guys in this. Your testimony helped our case. I know, and Brenda still barely speaks to me because of it, but I couldn't let her destroy people's lives. She was wrong and she needed to be stopped. How is she doing?" He sighed. "Adjusting to Florida. She hates it, actually. The HOA there is even stricter than what she tried to enforce here, and she can't stand being on the receiving end of petty rules." He smiled ruefully. "There's some irony in that." "There certainly is." For what it's worth, selling the house and moving was probably good for us. Fresh start away from the embarrassment, and I think losing that lawsuit humbled her at least a little bit. "I hope so. Nobody won in the end except maybe the lawyers. We all won," Harold corrected me. "You got to keep your driveway. The neighborhood is peaceful again, and Brenda learned she can't bulldoze people. That's worth something." We shook hands and parted ways. I thought about what he said. He was right in a way. Sometimes conflict is necessary to establish boundaries and teach important lessons. Brenda's overreach forced a confrontation that ultimately made Mountainside Estates a better place to live. As spring approaches, I'm planning some improvements to my property. Not because anyone is forcing me, but because I want to. I'm going to expand the garden beds flanking my gravel driveway and plant native flowers that attract butterflies. I'm going to add some landscape lighting to highlight the driveway's texture at night. I'm going to enjoy my home exactly as it is, with features that have character and history. And if any future HOA board ever decides to challenge pre-existing features again, well, they'll find a neighborhood that knows its rights and isn't afraid to defend them. That's Brenda's real legacy, though I doubt she'd appreciate the irony. By overreaching so egregiously, she actually weakened HOA authority in our community and empowered homeowners to stand up for themselves. My gravel driveway will remain gravel for as long as I own this house. It's grandfathered in, legally protected, and a point of pride. Every time I pull into it, I remember that property rights matter and that standing up to bullies, even institutional ones, is worth the effort. That's a lesson I'll carry with me long after the crushed granite eventually needs replacing decades from now. The neighborhood is quiet tonight as I finish writing this account. Lights glow in windows up and down the street. Tom's fence stands proudly at its original height. Margaret's gate gleams under her porch light. Mr. Chen's rock garden rests peacefully under the moonlight. And my gravel driveway crunches satisfyingly under my feet as I walk out to get the mail. Exactly as it has for 47 years and exactly as it should for decades more to come.